Contracts, right? We probably have some vague familiarity with them, even if we're not a transactional attorney, and the basic contract law dictum that you need right offer and acceptance and consideration to have a binding contract. And if you look historically speaking, certainly contracts are the basis in many respects of commercial civilization, sort of as we know it. And if you look back in history, early civilizations quite unsurprisingly had and adopted some form of contracts, some form of written document to just sort of show that, hey, a transaction happened at least, and sort of record keeping, or maybe here's a record and a set of promises that we have to each other that a transaction needs to happen. And ultimately, that's what a contract is about, not just a sort of a backwards-looking record of what happened, but also very much a forward-looking document that says, hey, we made these promises, they're legally binding, and we're going to perform obligations. And we can sort of look at that old clay cuneiform tablet, which actually was apparently recording payments in beer to workers. We can kind of laugh at it, it's anachronistic, obviously, but I want to argue for 2 seconds that there's something really good about this tablet in terms of contracting. Number one, it's written, so you can kind of know, there's like some objective barometer of who owed what to who and maybe when and how much. But it's also, because it's in a tablet form, it's very hard to tamper with. And if it may be immutable. It's sort of rock solid, if you will. So there's something good about that. And as contracts have become digitized, as we move to WordPerfect, and PDF, and other types of tools, right, to contract and record and negotiate documents, there is something that was lost in that respect as things became easy to change. But there are things also that are going to, technologies now, as contracts become increasingly digital with distributed ledger and blockchain technology, that are kind of going back to this sort of tamper-proof record of parties' obligations. And we'll certainly see that theme come back later in the talk. Okay, contracting, right? So what is contracting? It's a process. In the more business context, certainly, there's various aspects of it. And just to focus here on some of the basics so we just have a common framework to think about how and to what extent and what aspects contracts are becoming digitized now is that in the business context, you may request a form contract or a contract that's sort of been improved by a business. You may author some aspects of it, negotiate it with your counterparty, collaborate internally or with somebody else as well. Finally, the contract from the business sense is reviewed, gets approval. If there's something perhaps really unique about it, maybe attorneys need to look at it. Ultimately gets executed, so then parties start signing it, parties start performing, and to some extent, if there's business management aspects of contracts, you will look at what obligations need to be performed, what milestones, what payments need to be made, invoices need to be sent, and so forth. And then if the contract has they all have, to some extent, some termination period, so duration, so the contract is a 5-year contract, and it ends up that like a month, you need to either terminate the contract, terminate the relationship with the party, or sort of renew it as well. And then maybe during the course of the agreement, you may amend the contract, you renegotiate aspects of it and document that. In fact, the majority of commercial loan agreements from banks to companies are renegotiated, at least to some extent, because maybe parties are going to miss a payment or want to renegotiate the interest rate or the due dates, the duration of the loan. And so what are contracts used for? Well, sort of quite obviously to sort of document the responsibilities and rights of the two parties against each other in a sort of legalistic sense. But if there is going to be litigation, which was sort of left off of the other slide, what happens when things go bad? If there's going to be litigation, let me move over to maybe this side, of the stage. If there's going to be litigation, then we need to know who was supposed to do what, when, and at what time. But then after that, if you look at like some of the major purposes, and this slide comes from a survey done by the International Association of Commercial and Contract Management, business purposes, right? So beyond the sort of lawyerly, legalistic aspects of contracts, like you owe me this, and if you don't do that, then I have rights under the law. There's also business purposes that are being achieved by contracts, including risk management, relationship building, a framework for what is success in an outcome. Communication tool, recording what parties are doing in terms of setting milestones or service levels. And so certainly when you ask about what purpose does a contract serve, we have to say to some extent there is no single purpose. It could be a very simple obligation, record keeping. It could be something much broader and much more long-term focused. And if you think about the way business is trying to be done, the way general counsels and companies are trying to do their jobs, they are trying to take a more holistic approach to everything, including relationship management through contracts. And that's, I think, a useful survey to think about as we think about contracts becoming digital. What purposes beyond record keeping of rights and duties under the law, what purposes can digitization of contracts serve in more of a broader business framework as well? Okay, well, where are contracts stored? What do people just sort of do with them? Surprisingly, not surprisingly, I don't know, like any sort of data management, it's not as good as it probably should be. And you see these various sorts of surveys that people come about, even with attorneys, saying, you know what? A good chunk of attorneys don't necessarily properly keep records about their contracts, and they don't necessarily know where exactly they are, maybe which one necessarily is the most up-to-date one that governs certain obligations, maybe where the amendment is and so forth. And to some extent, they're just disorganized, right? And because of that, you have a wide variety of contract management software that comes into what is now known as sort of the modern tools that people use for contracts. But in addition to sort of just not being disorganized, if you look at a few surveys about what are the issues with contracts and what are some of the problems with them, you'll see some interesting answers. One of them is too slow, perhaps because contracts are not standardized, because there's no real common framework sometimes. You have to go through the same machinations over and over to get to that final point of signature. So contracts may be too slow. Another one in this survey that was done by Exari is that about 40% of the respondents here said, well, there's just not visibility into sort of on a real-time basis into what people are doing, how much risk is involved, and therefore sort of how much we may owe or do owe over time. So in that sense, the criticism of contracting is it only gives us a point-in-time framework for party relationships, basically when we signed it, but they're generally not necessarily being updated over time. Other problems are sort of missing milestones and deadlines and payment obligations from sort of a business perspective, with compliance issues, and maybe more mundane issues too with respect to administration, like risk, errors in compilation, just mistakes. Another survey had similar conclusions, but different ones. But again, just sort of highlighting the problems with contracts, even in this digital age, such as inconsistency, again, showing no necessary standards. And this is a survey from 2006, and I'll explain how things have probably improved since then. But inconsistency among different structures and templates. We all sort of know that most modern commercial contracts have some basic structure that's similar. The opening, the titles, the names of the parties, the recitals, the reps' warranties and conditions, signature block, and then sort of the performance based on the actual substance of the agreement. But many of them have a very similar structure, but apparently not enough, according to this survey. Again, the costliness of negotiating them, getting the deals done, the speed of which it's not being done, and the repetition, again, of doing the same thing sort of over and over, and the general sort of slowness of the whole process. And that's why you see sort of contract lifecycle management as a field of activity, as a type of software. So sort of just beyond what we saw earlier, authoring the contract, getting the approval, negotiating it, and executing it. There are a couple things on this slide I thought were really interesting and important, and it's something we need to think about as we go towards sort of smarter contracts. We have the approvals and the redlining and all that, but what this slide has are a couple things that we didn't see earlier and are worth highlighting, namely storage and search and sort of audit reporting. So it shows that contracts go beyond just simply being a tool for recording legal duties and rights, but also for being a form of record keeping for substantive business decisions, including having to deal with administrative aspects of that by, namely, keeping them stored somewhere properly where people can have access to them in a uniform manner, and searchable as well, because you want to kind of extract the data from them and have insights like any documents you have in a repository that are sort of live. And audit and reporting, sort of after the fact, having all these contracts, the ones that are signed, the ones that are expired perhaps, and see, okay, well, how did this impact our business relationship? And that is part of contract lifecycle management, which is frankly an excellent thing that has really forwarded business in so many ways, right? Large businesses, even medium-sized businesses, smaller ones even, that need to just sort of be organized, consolidate their records when it comes to contracts like anything else, and otherwise they just couldn't do business in the scale and the scope that they do. How prevalent is the use of this type of software, contract lifecycle management? Well, it's not, in 2006, again, the same survey from Paystream Advisors, it's not as widespread as you may think, as it should be. In other words, only 25% of companies in this survey, at least, will use a centralized contract management system. But about half have internal teams that sort of do it themselves without something more sort of off the shelf. And then about 30% has probably the most problematic approach, which is sort of silos to managing their contracts. And we all, I think, are aware of what's the problems that come with different teams, different departments having their own sort of records, their own versions of things, and maybe not communicating across the lines internally within a company. And that in principle can be alleviated with contract management software. So in that sense, the contracts have become more digitized. Nonetheless, though, there are still issues even with the best contract management software, namely that the contract management software is not managing the contracts per se, but it's really abstracting a different layer above the contracts to manage data about the contracts, or reports about the contracts, or summaries about the contracts. It's not the contracts themselves are being managed, it's sort of something else above that, which again is very helpful and useful, but the problem is that the contracts themselves are not necessarily being amended, being directly interacted with. It's just sort of this data layer. And frankly, to the extent now that we have the ability to track compliance with the performance of a contract management software, at least generally speaking, does not sort of do that. In other words, we will see sort of deadlines and milestones built into the software, like, hey, there's a payment due, there's a renewal that's up for notice, there's a notice that needs to be given, for example. But in terms of the overall payment and performance, was payment made, were the goods delivered, were the service levels met, contract management software is not so much about the real-time recording of that kind of performance. And finally, contract management software is a vertical, let's say, of software within the enterprise, but it's not necessarily, again, connected to other enterprise software systems, ERP systems, accounting, finance, and so forth. Increasingly, integrations through APIs are being built, but just by itself, even the best contract management software is kind of itself a silo, because you're just sort of managing contracts apart from the broader business context. But what else is going on here in the digital, as my talk was about contract digitization, what else is sort of going on? Well, contracts and the contracting process has certainly improved a lot because a lot more information is public than it used to be, certainly thanks to the internet. People are sort of taking the initiative to, for example, whether it's free or not. One example is contract standards. It has a really good repository of all these different types of contracts, relatively standardized, modern, that people can sort through and see sort of how our deal is getting done. And largely pulled from EDGAR, so the Securities and Exchange Commission's database of public filings of companies. What does it have to do with contracts? Well, if you're a public company and you enter into a material agreement, you have to disclose that contract, whatever it is, to the public. So that's where you can kind of pull down contracts. And beyond just sort of 10Qs and 10Ks and sort of financial securities disclosures, which are not really relevant to this discussion or contracting. This repository also allows you to search by clause and see different types of clauses. So let's just say you want an indemnification clause. You don't have to call someone from another department maybe, call a colleague, a different firm, a different attorney. You can say, well, here's 10 different versions that are all relatively widespread in practice of an indemnification clause using various contexts, from real estate to insurance or something. And these types of repositories, again, whether they're free or not, make the overall contracting process more rational and more standardized, and because of that, generally helps the market because of the network effects. How about analytics? Well, that's also a big part of everything that's going on in the business world, not just contracts. And we could have a major discussion about machine learning and artificial intelligence. And I'm sure another presenter could speak well to that. But the point is, all these tools that are basically used for taking data that's structured in some respect or another, organizing it, categorizing it, and then assembling it in a new way, and then being able to perform some kind of analytics, mathematical and econometric analysis on it, is also being applied to contracts, not just in the quantitative sense. So you can say, how much are all the obligations, how much are the liabilities, and the benefits and the revenues under certain contracts, and you can categorize in certain ways, as you can imagine, sort of standard corporate dashboard would show. What's interesting with a lot of contract analytics, it's also qualitative. It'll take a lot of these systems, as contracts have become digitized, allow you to, and this is one example of Kira's approach, allow you to scan in all your contracts, categorize them, digest them in a sense, process them in the system, and then compare them on a textual basis against each other and against sort of a standard repository. So you can say, this paragraph appears everywhere, and it's probably fine, but there's a couple troublesome paragraphs, clauses, sentences in a few of your contracts that make it perhaps riskier to use this language. Or you can go certainly search for problematic language that may be found in some of your contracts, including, of course, if a court decision comes down and says that this language now is no longer enforceable, or at least not as enforceable as you may have thought, introduces some legal risk, because a court decision in some state maybe call that into question. You can sort of go through your contracts, obviously electronically with a search function, and be able to find out which ones have that and perhaps amend it if needed. And so the analysis on a textual basis of contracts, both qualitative, other types of contracts, both qualitative and quantitative, is also, unsurprisingly probably, a big part of contract digitization, which makes that sort of more routine work better, less error-prone, and to that extent less costly. And as a result of those export reports, right, so the reports are exported, and you can sort of, in most of these systems, define what report you're looking for and what you do with that knowledge. As a result of that, you see what's increasingly happening is stories like this, where the most sophisticated approaches to these systems say, okay, now that we've sort of trained the computer to read a bunch of contracts and sort of pull out problematic language or whatever happens to be relevant to the question at hand, in a sense like a Docker view system, it allows us to really do legal work on a level that's never been able to be done before, overseen by humans but done by machines, right? So that level of automation is something to think about. And there's certainly broader debates about the role of technology in legal services going forward. But certainly what I wanted, my emphasis here is that that discussion, that use of technology is also happening in the contracts, in the contract area, at least with respect to sort of reviewing contracts for different types of language that may be problematic or not. And in this case is the COIN system of JP Morgan software reviewing commercial loan agreements for servicing issues. COIN being contract intelligence, C-O-I-N. And this sort of made headlines earlier this year. And I suspect there'll be many more types of these stories to come. But how about, what's the next sort of level? What's going on beyond the quote-unquote, basically the digitization of contracts, the contract lifecycle management, the contract analytics, and the sort of broad sharing of templates and open sourcing in the sense of that. What else is going on is what you may have heard as smart contracts. So smart cars, smart washing machines, and of course, smart contracts. So what does it mean for something to be smart in that sense? I mean, it basically means for something to be digital in some respect, to be automated to some extent, if not fully, and to be sort of internet connected. When we call something smart, that's usually one of the things we mean. So a smart washing machine is more digital than a traditional one. It can order soap automatically through its internet connection. And thinking about smart contracts is a similar aspect. And you also hear, so you see lots of headlines. You see Business 4.0, Enterprise 4.0, the new industrial revolution, right? Using all the a lot of buzzwords we hear, like blockchain and big data, but they certainly make sense because it really is about bringing contracts into the most modern technological framework with using data about contracts, using distributed ledger networks that we'll talk about, however briefly, about blockchains. In other words, contracts are really entering the modern era, and I think that will have important implications. They already do, to some extent, for attorneys, and it's good to keep abreast of them, at the very least. Okay, and so, as I mentioned, for something to be smart, often it is connected to the internet. I mean, they have smart toothbrushes now, so people can know when you did or did not last brush your teeth, perhaps. I think they have smart floss. I'm not sure. But in any case, it's internet connected, right? And it needs a battery, probably. It didn't before. And needs to have some Wi-Fi connection, whatever it is. And contracts, in a sense, are becoming the same way, because the revolution of the IoT, the Internet of Things, where all devices will be connected soon enough, right? We see all the big projections. By 2020, billions of devices will be connected to the internet in some way or respect, including probably the next wave of chairs that are purchased. We'll say who sat there, when, and for how long. Everything will be connected to the internet. And because of that, though, that has lots of implications. But because of that, for sort of the more narrow discussion about contracts, it allows really for the first time for contracts to give you, or be able to know, in a sense, about the real-time status of their performance. Okay, so you order goods online, and right now, you know, in the commercial context, if you order from an online retailer like Amazon, just for example, we get tracking notices sometimes. You can sort of look up the status of where our goods are. But in the commercial context, lots of that data, as is now being used in business, can kind of come more directly into the contract and impact, for example, when payments are supposed to be made, the status of warranties, when the invoice has been satisfied or not, accounts payable and everything. So you can just see as the performance of a contract, and in principle, no matter what it is, can be automated in real time, not just the Internet of Things, but also through various types of application programming interfaces that allow data to be transferred between two different software systems or otherwise. And then on the flip side, so you can bring data into the contract, so the contract sort of knows how well someone's doing. Okay, in the services context, you can also, in principle, see service level agreements that are being complied with or not. Whether it's IT infrastructure that has to keep the computers up for a certain amount of time, or some kind of maybe less technology-driven type of service, such as maybe something in the human resources area. Whatever it is, at least to some extent, it can be automated and brought into the digital realm, so you know, sort of as like a checklist, the milestones are being met to the contract, and therefore it can have implications, not just in the payment side, but also in the other enterprise software. So you know if the risk manager or the financial manager is sort of wondering where the payments are, how late are they, that can be automatically brought into the contractual context too. It doesn't have to go through a contract management system, because the contract itself starts to manage itself. So the concept of self-managing contracts, like self-driving cars, does become a reality to some extent. And that is sort of where the future, in some respects, of smart contracts are going. But this is, in a sense, it's nothing new, because there have been several initiatives and fair amount of progress over the past decades to make contracts smart in the sense of making them not just machine readable, but in a sense computable. So that the text of a contract, the rights, the duties, the performance of it, trying to say, okay, how can we think of this from a sort of computer science maybe standpoint? Or at least some type of web markup language. And so for a while, you've seen things like the following. This comes from legal XML. And the idea is that just to say, hey, let's, just like we have a web page, we have HTML, we can sort of categorize different pieces of the website as like the title, the heading, the images, the links, whatever it is. Why don't we have the contract? Because contracts are, to some extent, largely standardized. Again, you have the introduction, the recitals, the names of the parties, maybe the recognition that there's consideration. Okay, so why don't we just sort of tag contracts in that respect, allow people to sort of code them or tag them, and then make them not just machine readable for the analytics purposes, but also sort of machine executable. And that's one approach, markup languages that are relatively straightforward. But how about using more sophisticated types of computer science and programming languages? And so now you see a burgeoning literature, and this is just to make you aware of what's sort of going on with respect to sort of computer science and law. There's a bunch of computer scientists just basically exploring or debating about the best way to think of using contract code or using computer code and software to sort of define and structure the obligations of parties in a contract as well. And this is one paper. And the point of this paper is to say, look, most contracts can basically be broken into a series of if-then statements. If someone does that, then we'll do that. If they don't do that, then we'll have another consequence. If you pay your loans on time, then the normal state goes. If you miss a payment, then we go into the default stage of the loan. Maybe the interest rate changes or what have you. And most types of contractual obligations that can fit that simple if-then framework can be relatively quickly and at least straightforwardly automated and be put into the computable framework. There's also background conditions like choice of law or arbitration, whatever it is, that are not so much if-then, but they're just sort of background conditions that are not really so much computable. And there's also a series of much more subjective statements about whether performance has actually taken place or at least properly to the satisfaction of one party or another. But to the extent that data can sort of in a binary sense say, yes, you performed your obligations, then can fit more easily into a framework. Well, even beyond that, we can go a little bit deeper into computer science, and like how do we store it in memory, how do we structure it? There's many approaches. And the only point of this paper is to say, it seems like the one on the right is maybe better because it's more straightforward, it's more simple, maybe it matches natural language a little bit more. But this is sort of a debate, and there's no clear answer at the moment necessarily what programming language to use, what programming paradigm to use, but something that people have been looking at, certainly now much more than before, but it's also something that's been in the computer science literature for decades, where people are using something called domain-specific languages, DSLs, to say, let's just make something more specific to the contracts, a computer language just for that. And the only point of that, and the point of knowing that, is just to say, it'll make the process a bit simpler because we know that we're just coding a relatively limited set of parameters and a relatively limited set of logic and structures. If we use something that's more a language that's more geared towards contracts as opposed to like some universal programming language, which probably is not necessary. And so you see also some distinctions and tensions between, okay, so how far should we go? Right? And this is a debate that takes place in other areas, but should we completely code the contract into code from natural language to go to code? What lawyers would understand that? What judges would understand that? If there's no real natural language text, but maybe fairly readable high-level language that has computer code, and the computer code is still intelligible, it's processable by humans, and that could indicate the performance obligations of the parties, like a contract. You can sign that, let's say digitally, or maybe with a cryptographic signature or something. So that's one tension. And then you have various commentators, and in practice, people are saying, well, maybe we'll make the text on the one hand similar, and then we'll have like a code behind it, so kind of like a matching up of text to code. Maybe we'll have something more of a mix approach where we have like something that looks like a normal contract with natural language, but a few of the clauses will be written in pure computer code, because those are the ones that are really data-driven, like delivery and payment and so forth. And it'll be written in a high-level enough code that you can basically understand it and what's going on without necessarily being a computer programmer. I mean, that's just another approach. I'm not sure exactly what's the best. At this point, different contexts would require or benefit from different approaches. I do think some kind of mixed approach certainly makes the most sense as opposed to having pure code. Because with pure code, just like natural language, things can go wrong, and then you say, well, whose code, what was the intent behind the computer code? And we've seen sort of things like that have happened in not too recent past. And then there's just a general debate about automation. Are people prepared to sign a contract and live by the results of the automatic computer code? That if you miss the payments, you get locked out of your car, right? There's already some systems and stories about that. How far are people willing to go for automation? The answer tends to be not completely. Automation of some things with like some human fail-safe mechanisms to sort of override it. But again, that general aspect of automation is part of the contract, the process of contract digitization that's happening, but also a much more widespread issue in business and, in fact, society, certainly. And they tend to go together, but I would not mix code with being manual in the sense, or being, automated. You can have something that's very sort of in code or driven by code or coded up, but you can still have manual interventions or manual input in a way that's digital, but still has human beings substantially involved. And things can be a bit more manual also with, or some things can be automated, let's say, with not necessarily taking the pure code approach either, if you have the code sitting behind the contract, for example. So what's one approach? Well, a sort of blockchain banking consortium. Yes, sir. Question. Yeah, exactly. And so the question here was, great question, is like, well, we can deal with this. So have it basically, not to misconstrue your question, have some kind of escape hatch that says if the code goes wrong in some definable way and maybe both parties agree on it, we can go back to natural language. So if the program stops working and payments don't get sent or whatever it is, yeah, and I think that is a good approach that makes sense and people have definitely proffered as well. And I think that kind of sort of mixed natural language code approach with basically some new language, new provisions to say, hey, this is how we are going to deal with potential bugs and errors that we don't deal with. It shouldn't be too problematic, in fact. And in fact, lots of contracts today certainly rely on technology to carry out the business process aspects of the contract as well. Things can go wrong, language can be misinterpreted, and in that respect, either we go to more general dispute resolution or have certain fail-safes as well. Absolutely. So here's one approach that sort of R3, a banking consortium, smart contracting company, has just sort of proffered as a way to have sort of contract code match up with the natural language of the enforceable agreement. Because the big issue is enforceability at the end of the day, right? The issue is, are these obligations that are run by data going to be enforceable? So just because the data says you did something, does that mean you did something for legal purposes? Probably, but there needs to be some thought given to that. There needs to be some standards developed around that, I think, as well, as I'll discuss in a bit. And so here we have sort of legal prose that can be just read in natural language, and the code that matches up to that. And this example comes from trade finance, which basically says that you release the payments to the seller when the documentation proves that the seller has shipped the goods basically as asked for in traditional sort of letter of credit trade finance area. By the way, are there any more questions out there that I may have missed? Okay, great. So that's one approach to sort of thinking about it. And then sort of the next issue we need to deal with is smart contracts and blockchains. Oftentimes very confusing phrases and terms. So it's one thing to distinguish them first and then think about some of the different aspects of them. Okay, so first is, what is a smart contract? I've used it in a more, I think, straightforward sense of being a legal agreement that has, like anything else that we call smart these days, some digital, connected, or automated aspect to it. But oftentimes you will see the phrase smart contract used in a much broader sense to refer to code that is executed or stored or run, however you want to describe it, using a distributed ledger network or a blockchain, whether or not it's linked to an actual legal agreement or legal obligation at all, in a very broad sense. But another sense, we can call them smart legal contracts, because we probably care about legality, being in this room here. A smart legal agreement is basically an enforceable agreement that happens to be executed or stored or digitized or automated through some digital process, and it could use a blockchain. I say could use a blockchain because it doesn't have to, of course. I mean, in a sense, your automatic payments for your monthly subscriptions, in a sense, are a smart contract because you're basically signing it and agreeing for money to be pulled out of your account every month for whatever subscriptions you may have. But doesn't use a blockchain, certainly, some kind of distributed ledger network. And so in that sense, it's smart. But here in the smart legal contract, we're saying it should probably uses some kind of tamper-proof execution of computer code, i.e. a blockchain. And the reason I bolded tamper-proof execution, because that brings us, in my opinion, back to that cuneiform tablet, right? In the first slide, or technically the second slide after the intro. Where I go back to that tablet, it goes back to the idea that if we're going to actually start doing contracts in a very digital native environment with maybe no corresponding paper or PDF copies, or a Word document, if we're going to start automating transactions, we need to be really safe. Okay, contracts, in a sense, can be dangerous from a legal risk and business perspective, so we need just to be sure that we're sort of on the same page and that no one can mess around with the contract once we sign it. And that was, I think, the beauty of that tablet is that it would take a long time probably to etch a new obligation into the stone tablet. And because it's very easy to create a new Word document, probably easier to create a new Word document relative to a new stone tablet, we need to safeguard ourselves in the digital area, right? Not just cybersecurity, but just tampering in general. And that is where blockchains come in. And that's why the idea there is, if we're going to run on digital networks, the digital networks need to be safe and immutable to some extent, and not easily modified by one party or a third party without knowledge of others. And so that is where blockchains come in. And there was a great presentation yesterday about blockchains and Bitcoin. For sort of context for those of you who were there, or for those of you that weren't there, I'll quickly talk about just two aspects of blockchains, or distributed ledgers more broadly. So I'm sure we've all heard to some extent of blockchains as being like the new revolution in computing. That's going to do a lot of good things. To some extent, it already is starting to, and I agree with that assessment, certainly. There's hype around a lot of things and different aspects of new innovations, but I think in two respects, I can identify two characteristics of blockchains that make them, and at least in some respects, very suitable for this new type of digital and automated and internet-connected contract. One is distributed. Okay, so I think this image, more than any other, really illustrates the difference of a blockchain versus traditional transaction execution. So assuming we're already in a digital native environment, there has to be some company, some entity, some bank, some clearinghouse, if you're in the financial area, that's just keeping a record of transactions. An accountant, whoever, there has to be some final record, and that is traditionally done through a central party. And it's especially important in the digital area because we can, relative to maybe paper and stone tablets, relatively easy to modify digital data. And so we need to have it, safeguarded, properly accountable, properly secured with passwords and so forth, central party that we trust. And oftentimes in the legal context, that central party is regulated, maybe as a bank, a broker, a clearinghouse, a trusted intermediary of some sort at the federal state level. And they provide the trust, you know who they are, and they provide the actual administration of the record keeping. So I would, for example, keep the record of who attended this event and be sure not to spam me afterwards. But in the context of distributed ledgers, what sort of blockchain and Bitcoin made possible for the first time is to have safe record keeping, that's what we call a ledger, safe execution of transactions perhaps, and the record keeping of the transactions without that central party, whoever it is, a bank or a custodian or any kind of other entity, a boss, right? And the idea there is, well, instead of one person keeping the notebook, keeping the record, there won't be that one person. The answer is, okay, the question should be, where's that notebook? The answer is, we all keep it. So instead of one central ledger, everybody keeps a ledger. That way, there is a ledger still, but it's just that there's no central party that has it. And so then that creates a lot of new questions, like how do we make sure that we all have the same ledger? And that's where the underlying sort of software system comes into play. That says if one person has a transaction that's valid and updates their ledger, everybody can see that, and everybody has to update their ledgers accordingly. So each of you are keeping track of, let's say, who attended this talk today and who didn't. And that is the framework for blockchains in the purest sense. And that's why they call it a distributed ledger as opposed to a centralized ledger. But that does mean, though, we need to have pretty solid rules about how we update ledgers, because we need to all be on the same page. no pun intended, we also, and that's why you may hear that blockchains are much less efficient. And in that principal sense, they are much less efficient because it's much faster to have a central entity just updating who gave money to who or who transacted when. If all of us have to do it, it can take a lot of time because each of our separate computers may have to do it. So it may take 4 minutes or 10 minutes for like a standard transaction on a blockchain versus 4 seconds or even faster for like a typical credit card network. But there is that delay and lag, and there's certainly people trying to solve some of those problems. Another important aspect of blockchain, I would say, is that it's a universal ledger. So, and it may seem counterintuitive that something that is not centralized, that is distributed, is also universal, but the very property of being distributed means that we all have access to that data. We don't necessarily have to, but that's in the pure sense of a public blockchain like Bitcoin or Ethereum. It's distributed and public, and we can see at least maybe not the names of the parties, but the transactions that are happening. And because of that, it does serve in theory, or at least the goal, is to serve as like a universal record, a golden record of truth. And we think about some of the earlier problems of contract management and just general record keeping in the digital age is silos between data sources and records, not to mention different types of structures and formats and everything. And so you oftentimes see, like in this diagram, the Internet of Things, which has data coming from many, many different sources and different types of, let's say, data, ultimately being consolidated in one universal network, i.e. a blockchain. So whether it's data from a home device, a washer, a TV, smart car, smart toaster, whatever it is, we can put all the data and the process involved with the data that this slide talks about, registering new devices, authenticating the devices and users, maybe selling the power, selling the new soap, whatever it is. There is some aspect of it that is certainly local and specific to like the machine, but there's also a benefit that comes from it to being universal. And we can easily sort of transplant that idea to contracts. You know, 2 parties may have their contract, and they don't want to share certainly maybe anything, but certainly not everything with the entire world or even some selected network. But there may be benefits to everyone that are parties to this contract or group of contracts to contracting in a general environment where it says, okay, if you guys are going to negotiate, we don't need to know that, but if a payment's going to be transferred from one party to another, it could be benefited to know that happened. It could benefit a lot of parties, and maybe it's just like different offices of the same bank. Just need to know that. It's easier for like one large company, let's say, to know what's going on internally, but it could be a select group of different institutions, and it could be certainly what some blockchains aim to be is a sort of universal global computer for everything in the most public and broadest sense. And so let's get lawyerly again, if you don't mind. Are these smart contracts, are these transactions that are being automated and processed through these distributed, everyone has a copy of them, networks? Maybe not. It depends, right? The whole point of smart legal contracts and the movement sort of attorneys to get in this area is to say, well, we want to be sure not just to automate business transactions. In some respects, it's almost trivial, technically speaking, these days. Sure, you can say, do this, if this, then send the payment. If that, unlock the door. But how do we comport that with evidentiary requirements, as was discussed yesterday? How do we comply that with maybe data privacy? How do we comply that with just pure legal enforceability? I mean, yes, the door was unlocked when somebody walked up to the house because they had the proper sensor device on them, but was that sort of authorized by the contract that was underlying that? Was that part of the scopes and obligations of the seller of the device to the user? There's a whole host of legal questions you can ask that need to be asked and answered when contracts or business processes become digitized. And so here is a smart contract on a blockchain smart contract, but it's not necessarily tied to any legal contract in the sense of something that had offer, acceptance, and consideration as we would typically understand that as lawyers, and which are necessary. Not to mention the amendment. Let's just say something changes. Is that necessarily part of the scope of the amendment process, which typically requires new negotiation and consideration, or at least communication between the parties? These are sort of open-ended questions. And people have answered them in different ways. Okay, how do we connect these digital contracts to these secure networks to make at least a contract secure? Again, going back to the stone tablet, right? We need contracts to be secure. We can't have them be just Word documents that anyone can copy and paste and delete. Even a PDF you can change now. If you want to know how, ask me afterwards. So let's taking for granted that some kind of distributed framework that we can all see changes is more secure, like a blockchain. How do we do it? Well, academics and practitioners and technologists have different approaches too, but we can categorize them into two broad classes. I call them blockchain light or blockchain heavy. And one idea is to basically enter into the normal contracting process and maybe like a centralized server at the top, on the top of this slide, and then use a blockchain for something very specific, just to store maybe the data associated with the contract or a hash of the data. But really use the central party between the two parties, that's doing the execution. That's just one example. Maybe you store just some of the identity of the parties because you want to share that, maybe for regulatory purposes. On the other hand, but you don't execute you don't run the whole contract on a distributed ledger network, so in principle, everyone can see what's going on. That would be the blockchain-heavy approach. The blockchain-heavy approach says, take a contract and basically put everything about it from a digital perspective on a blockchain and run it there. And that would be basically the approach of Ethereum smart contracts, which in principle say, we're a global computer, and we want to run and execute and compile everything about the contract on this blockchain. And there's privacy problems with that. There are just scalability and cost problems with that. There are speed requirements, because if everything that's required about the contract requires everyone to agree and update their own personal notebooks, to bring it back to that metaphor, it's going to take a while. It could take longer than necessary to just note that party A edited their contract, because any change would have to be reflected in a global database. Again, there's different approaches. The blockchain light approach seems to be the appropriate approach that balances the need for trust and immutability and tamper-proof security of contracts with still the other needs for privacy, speed, and scalability as well. And so in principle, there's a legion and no end to the types of applications and use cases for smart contracts, but certainly commercial agreements that we've discussed, supply chain is very rife for that. Supply chain generally is becoming much more digitized by itself, much more automated, and so bringing contracts into that process, again, is becoming just part of that general move in enterprise of being digital, automated, internet connected. Bringing the contract in that process just makes sense. It's sort of a natural fit, despite the complexities. Finance and insurance, of course, because the payments and the transfers have long been really digital entries in a bank's records, that automating that further with smart contracts is probably the shortest step to take when it comes to applications. And that's why you'll see a lot of times blockchains being discussed in the context of financial institutions and transactions, because to some extent they're largely already standardized and able to be automated. And to some extent, they already are prior to blockchains, like how much collateral a derivatives transaction is required and sort of who owns it when. But people are also talking about different types of new applications, so basically trying to rationalize and clean up all of the agreements, the deeds, the titles that are associated with real property transactions, and again, bring them out sort of the silos and the non-standardized approaches that are being taken there. UCC filings as well for basically the state-based registry for personal property. Okay, when a borrower's personal property serves as collateral, that type of filing also could be, again, put on a network that's just more easily accessible and searchable. And not to mention automating some of the aspects of the payments associated with the sale and the use of the proceeds of sales of a foreclosure action towards the loan principal. And that brings me to the final aspect of this talk is about standards. So over time, large-scale fundamental infrastructure changes that have happened on a market-wide basis, law, business, or some combination thereof, have often come about through standards organizations as well. For, I think, the obvious reasons that having some kind of basis from which to do business and to process transactions, whether they're being safe from the perspective, let's say, the ISO standards or being in the proper format of data, just helps everyone from network effects. At least we all have some starting point. And then one theme, if you think about through what I've been talking about today, is that there's so many different approaches. I mean, which is great. Obviously, with any new innovation technology, of course, there's not going to be one way to do things. No one knows the right way to do things in the smart contracts blockchain space. Certainly not. But over time, as the technology is starting to develop, as common problems and issues are creeping up, including the legal issues that need to be addressed, including perhaps just like entering this new type of language into contracts, fail-safe mechanisms, new types of dispute resolution, perhaps, that take into account the new types of problems that come about with new technology, standards can develop. And for that reason, the core project was formed by myself and some colleagues, a nonprofit organization to set standards in this area. And we've teamed up with a lot of great partners to just set some baseline level of technological standards, legal standards, and combine that with open source software, which is free software to the public. Because open source software, the tie-in there is that sets a standard for people to run applications and programs by saying, hey, if we all use this software that's already publicly available in some open source software repository, and then we kind of maybe just use it or change it or modify it, at least we have a common reference point, a starting point. And that's similar to a contract template, if you think about it. Everyone starts with a template and obviously modifies it to their own clients' particular needs or the transactional needs, and there's sort of a good consistency there because as smart legal contracts become digitized and become sort of part of this more broader open source software framework, at least in principle, setting standards and bringing open source applications is important. And the core project was launched with some great partners, including Clio, with support there a few months ago. We've had our launch events, and we're getting attorneys and technologists involved in our various working groups, like supply chain, digital marketing, and so forth. And we're trying to answer some of the really important questions. Right? So take a step back again. In a sense, a theme or a summary of everything I've talked about are addressing these technical, legal issues, sometimes a combination of both, is what kind of data format do we use? If we're going to code a contract and have one company's system process it versus my company's system. Because the buyer's system may be very different than the seller's, can they necessarily read the same data format? How do we modify the text of a contract to say, if this data source and this sensor says it's true, then it's true, and the parties are bound by it? What kind of language do we need in contracts? How is the court going to view that? It's probably relatively straightforward, but it's good to have standards in that area. How about coming from the templates? Just what sort of baseline templates do we need that maybe has that new language, has sort of the ability to plug into external data sources as well? How about the evidence that's needed, the record of information that needs to be kept for evidentiary purposes? So if you're going to let a computer essentially manage this relationship on some level, who's storing that data? What format is it in, perhaps? Who has access to it? And if something does go wrong, how do we know that nothing was changed over time? Certainly, if we don't use a digital framework, we don't have that benefit of having necessarily a completely electronic paper trail. But at least we don't have the problem either of necessarily being bound to it. We can use maybe some third-party service or just some other more standard type of evidence to prove up something in a contract. In other words, the bank didn't send the payment, and we can show you my email inbox. And the bank says, no, we didn't debit their account. End of story. How do we integrate contracts into existing enterprise systems, which themselves are very much in flux, right? So there's the maybe more traditional ERP systems. There's sort of more web-based, cloud-based systems Okay, how do contracts come in that framework? There's probably no perfect answer. There's going to be varying approaches. There's always going to be trade-offs, but if we're all doing things differently, it would certainly recede or hinder the development of the market. And that's why, again, those standards organizations were formed in the past. And so I'll end my talk there. I really encourage you to get in touch with myself. If you have more questions, I'll stay here for questions. I don't think we need to leave right now. And I also encourage you to get involved in the Accord project, a nonprofit, if you're interested in getting setting standards and helping out there for smart legal contracts as well. And that is the formal end of my talk. Are there any questions? Any more questions from the audience? Yes, sir.
Very nice in the structure, but you always have to consider that you also have the tax authorities involved and the legal obligation to contain your agreement.
Yeah.
How does this fit together?
You say the tax authorities.
Yes.
Yeah, certainly, whether it's tax or regulatory issues, we just really began to skim the surface. But so far, most tax and regulatory authorities have treated automated transactions as essentially still being subject to their regulatory regime. So a security that is, let's say, issued, let's say, for example, Bitcoin or whatever it is still considered a security under federal securities laws, has to comply with anti-money laundering regulation and so forth, and will be taxed as property. So regulators do have some thinking to do about how to fit more traditional frameworks into transactions that are not necessarily so traditional. I would say, nonetheless, even though you're using a distributed ledger framework, traditional regulation, for better or worse, still fits into the transaction. I think the one thing that's very different, though, especially for regulatory purposes, is when you don't have that centrally regulated bank anymore. If you can process payments, make loans, without anything that looks like a regulated institution, that is a paradigm shift in some respects. And different regulators are dealing with that in different ways. One way is just to regulate the users and say, if you are transmitting money without a federally regulated and registered money service business, which is the federal approach to anti-money laundering regulation, then you have to comply with it in any case yourselves. And so you basically become subject to existing frameworks. How about we wait for the microphone? Thanks.
Have you examined how the securities industry has, approached the speed of their transactions? Because, it used to be transaction plus 5 to settle. Now it's transaction plus 3.
Yeah.
They're headed to transaction plus 2. And, they have, multiple transfer agents and then multiple registrars, but they keep moving towards, immediate transaction speeds, because look at the quantity of transactions all over the world. It's
right.
We're talking trillions of dollars a day.
Yeah, so in the United States, we have T+3 or T+2 settlement times under the law and practice for basically completing and clearing financial securities transactions. And things are moving to speed those up. And it's more of a technical problem. It's more of a practice and maybe perhaps legal problem than a technical problem. And yeah, and blockchain technology is being used, or at least is being experimented with, to help speed up those settlement times in a way that also has the other benefits of distributed computing. Great, I think we are out of time. So I want to thank everybody for coming in today. I hope to see you around later. Thank you very much.